Hello and good day, everyone. My name is Andy Cervantes, and I'm currently doing a research presentation regarding civil procedures. And shall we continue to the next slide so we can see further? The agenda for at least the civil procedures is regarding one of three things: phases of litigation, procedures in the pretrial process, and then procedures during the trial process. Phases of litigation. So phase of litigation regards pretrial phases, trial phase, and post-trial phase. Pretrial involves investigation, pleading, and discovery of information. The trial phase in itself, though, is just mainly used for opening statements, presentation of evidence, and closing arguments. And post-trial ends with either a settlement being reached by both parties or a potential appeal if there is any potential legal error due to during the trial. So the pretrial process. The pretrial process in itself will involve four things. It involves filing of pleads, gathering evidence/discovery, pretrial conference, and jury selection. Filing of pleadings. Filing pleadings can be of one of four things: submit complaint, summon and response, motion to dismiss, or motion for judgment. When it comes to submitting complaint, there will be used a thing called a service of process that notifies the defendant of a lawsuit, to which then the defendant is summoned and will be required to submit an answer and or response to the plaintiff. But the defendant can also raise affirmative defense towards why they are not at fault for such issues for a civil and or criminal case. And then there's also the use of motion to dismiss, which involves asking the court to dismiss a case for reasons that may have been stated for the motion. Along, it could also be used for a motion of judgment, which is mainly just asking the court to decide the issues by only with the use of pleading without proceeding to trial. Evidence/discoveries can also be obtained from opposing parties, deposition, impeach, or interrogatories. Discovery involves obtaining information from opposing parties, witness prior to the trial. Then the deposition is provided as a sworn testimony by a party to be questioned by attorneys from both sides. As for impeach, it's just summons to either party witness that changes their testimony in trial. And interrogatories are just written questions that require written answers that are signed under oath. Pretrial conference involves three things: A, meet with the judge in a pretrial conference; B, explore possibilities of a settlement without trial; or C, identify matters in disputes and plan the course of the trial. Jury selection involves the use of voir dire, which the attorneys would determine if any juror has some type of bias that may affect the court case. And if that appears to be so, the juror will then be dismissed from the case itself. Now, procedures during the trial will involve four things: opening statements, rule of evidence, examination, and closing arguments. The process of a trial will now begin with opening statements, and this could be by set forth the facts to prove and also brief version of facts, which would be in the sense of both parties will bring their side of the case with the facts they'll provide and try to prove it in the court. Regarding rule of evidence, there's also relevant evidence and hearsay. Relevant evidence of itself involves proving or disproving information to have a degree of probability of such fact, while hearsay involves someone giving a statement made by another individual that was not under oath. Examination of itself can either be direct or cross-examined. Direct examination involves examination of a witness by an attorney, while the idea of cross-examination is questioning an opposing witness during the trial. But then you also have rebuttal, which is regarding the refutation of evidence introduced by an adverse party's attorney. Closing arguments will then be made at the end of the trial for both the plaintiff and the defendant, which summarizes the facts of the evidence from the trial. The verdict is then issued as a formal decision made by the jury in favor towards one party. In conclusion, different phases of the trials it's just a lengthy process with strict procedures, and this requires constant vigilance and also upkeep regarding the court case with the information provided. Thank you very much for listening to my presentation, and I hope you all have a happy and safe day.